I definitely want the instruction on false imprisonment and your issue. I really want it resolved tomorrow, so conceivably it'll be given on Friday to the jury.
I think we can do that, Your Honor. I thought we were going to try to address the intentional infliction suicide instruction, and which I think we're close on with the court needing to make one call, and then the instruction on punitive damages. I'm ready to talk about those if there's time, but if there's not,
I've got the time. Do you all want to do it right now?
I'm happy to do those two. There, on a parent agency, there was a really minor issue as well. We might be able to get all that done.
So, what number am I looking at? What den am I looking at this point?
May I please, court? We've got witnesses to prep. May we leave this in the capable hands, Mr. Allege?
It's fine with me.
Thank you.
Your Honor, 3425 is our memo on giving the standard punitive damage instruction. And it was in sort of further response to a more, what would you call it, multiple issue memo that the defense had filed about instructions. And I think the defense argument was, well, you didn't plead certain things, so you can't have an instruction, punitive damage instruction on that. But actually we did, because we point out the plaintiff's 8th amended complaint on paragraph 26.
Well, perhaps, Mr. Allege, what will be helpful is if I hear what Mr. Altenburn's concern is, and then we'll get to your response.
Okay.
Is that doable? So, Mr. Altenburn, what DIN number do you want me to go to at this point?
The actual instruction that we proposed is in 3397.
3397.
And I think the legal arguments are such that we probably don't need to look at that. And the punitive instruction there is going to be on about page. Well, it begins on page 15 of 49. It's a little off because it contemplated that Ms. Beatty would be a party at the time. But the critical thing is, and the distinction between us, is that they want to have the instruction based on the standard language coming out of section 768.72 with the 3 things that can make corporation liable under the statute. But in this case, and those things are that the corporation actively and knowingly participated in the conduct, or that officers, directors, or managers condoned the conduct, or that the employer or the corporation engaged in gross negligence, and that contributed to the loss, or the 3 standards in the statute. When they filed a motion to amend for punitive damages, you entered an order saying that they were entitled to amend. We appealed that. That's been resolved, and that's not what I'm talking about here. But when they chose to amend their complaint, and this court entered an order, their chosen language was not the language of 768.72. Instead, in the complaint, in the first 2 counts, which are the only ones involved, for example, in one of the interlineations that sort of was amended into this in paragraph 74 is that the actions of All Children's Hospital were willful, wanton, malicious, and evidence to callous and intentional disregard for the life, health, and well-being of their patient, Maya Kowalski, which actions and or inactions as pled herein are substantially contributed to grievous physical, emotional, and psychological injury to Maya Kowalski. Now, when this case came up for trial a year ago, May, I pointed out then that the I couldn't do the standard jury instructions based on the statute because that's not what they pled. They pled a different standard for that. And at that point in time, I'm sure they didn't want to amend because they were hoping to go to trial, but that did not happen. And since then, the complaint has been amended, I believe, twice. We're on the 8th amendment complaint, and they've never ever changed the language of punitive damages. So my position is that they have elected to have as the standard for punitive damages the language in their complaint, and that doesn't fit the statutory language at all. And if your honor disagrees with that and says we need to use the language from the statute instead, well, this is a claim for punitive damages is not a just add-on element of damage. It's a separate claim for punitive damages. It's supposed to have been pled under Rule 1.110B, I believe it is, so that it states a cause of action and it contains a short and plain statement of the ultimate facts showing that the pleader is entitled to that relief. And none of these elements were really pled in that action. The one I'm probably most concerned about is the subsection C of the statute, which is that the corporation engaged in conduct that constituted gross negligence that contributed to the loss. But there's not once that they even use the legal conclusion of gross negligence any place in this complaint. The counts we're involved with here are counts that the employee at least was engaged in intentional conduct. And so I don't want to have them trying to prove up some gross negligence claim that I've never had a pleading on at all. So I think that they have elected the language they put into their complaint, and that's the legal standard and the factual basis to their punitive damages claim. But if not, then at least when it comes time to evaluate this, it's not all three standards from the statute.
Mr. Elliott.
Okay, Your Honor, our response is that 3425, docket index number. And sort of preliminarily, of course, we have, unlike the suicide situation, we have a standard instruction, and the presumption is you give the standard instruction. Then we move on and we note a case that says, the complaint is a tentative outline of the position the pleader takes before his case is fully developed on the facts through discovery and evidence. Cite the case for that. Now, and then the statute itself, 768.72, draws a distinction between pleading and what the jury then considers. So those are two different things. But I think the main difference here, or main thing that's being overlooked, is that the plaintiff's Eighth Amendment complaint, which is 2816, if you look at page 6 of that, 26. When the plaintiffs are pleading for punitive damages, they say, quote, based on the actions and outcome described in this court's order granting leave to allege punitive damages, and the factual underpinnings are incorporated by reference. Your Honor entered two orders. The longer one, there's one at 2034, and then there was one on clarification, rehearing, and so forth, reconsideration at 2103. And we've recited in the memo here, Your Honor goes to great length in there to describe some of the actions. And on page 4, talking about that Beatty was acting, and I guess there's some similar names. There's a risk management committee and a risk management department. And as I understand it, I think while the risk management committee, which had a lawyer on it, apparently knew of some of this stuff, I guess they weren't the ones that were hands-on directing. The risk management department was. And Your Honor goes on page 8 of that longer order, talking about what was done and what Beatty testified to. She's told to do this by the risk management department. Well, that's management. I mean, I understand there's been some discussion that, that department just had a bunch of retired nurses or something like that on it. It didn't have an officer on it. Well, Your Honor, if they take a committee or a department that's going to be in charge and dictating orders or providing instructions to people, and they want to staff it, I really don't care who they staff it with. They've given them authority to tell Beatty to do these things. And again, Your Honor recites some of those things in the order, and then those are incorporated by reference. So there is this greater detail that we're hearing should be there, is there. It's incorporated by reference from your order. So I think we are there. We should give the standard instruction. That's what's presumed correct. The requested instruction on, I guess this, what is this, page 16, just wants to talk about whether Beatty was a manager, and that's where that's going. And that's not what this case is all about. So we think the standard instruction is warranted. We think it is pled enough, not that it needed to be pled in exact detail, because the pleading, again, is different from the issue the jury decides.
Anything further, Mr. Altenberg?
Your Honor, first of all, whether it's one risk group or another risk group is probably an issue of fact that we'll have to figure out down the road as the testimony comes out on that. But and Mr. Ellicott is talking about the language of the wherefore clause in 75C on page 26 of the complaint. I'm relying on my memory, but I'm pretty certain that the language for punitive damages based on actions and outcomes described in this court's order granting leave to allege punitive damages was actually stricken from this complaint by you at some point in time because you didn't want to have them incorporating your order into their pleading. So I don't know that that's actually even there. But one way or the other, the punitive damages statute, rather, in subsection 1 talks about the process of getting the right to amend, but it doesn't contain language about what you put in or choose to put in your amendment. And what they chose to put in was simply that these legal conclusions about willful, wanton, and the like, rather than telling me that someone was grossly negligent or the like. So I don't believe that they're entitled to the benefit of the statute when they didn't plead the ultimate, they didn't plead that as a legal conclusion at all in their complaint, and they didn't lay out the facts other than perhaps some facts that may go to one prong of this.
Having reviewed my orders on allowing punitive damages and then the order on the reconsideration that Jay Hatch filed, I am comfortable that the gross negligence is included, and therefore that variant would also be subject to being instructed upon, obviously depending on what actually comes in.
Sure.
So I guess what I'm ruling, Mr. Altenburn, is I disagree with your position that the pleadings preclude that variant of punitive damages for just those two claims.
And therefore you want the final instructions to be based on the statutory language rather than on the pleadings.
Exactly. Now it looks like you have other items in here. I don't know if those are disagreed to or not.
As to punitive damages, I suspect that Mr. Ellicott and I will probably end up that this was the big fight. So I think we can probably work on the standards at that point in time. Because you just told me you want the gross negligence standard in there, and one of the concerns was which elements. So at least for purposes of now, we'll probably put all three elements of the statute in pursuant to your order.
Because I think in my order I indicated that the proffer was sufficient for any of the three variants.
I think you did, yes. My position was that after you told them they had the opportunity to plead that, you didn't.
I understand.
Okay. Thank you, Your Honor. I think maybe next is I think it would be useful to the parties to have a determination on I guess we'll call it the suicide or intentional infliction standard. We're proposing language, and it is, I'm looking for in our DIN 3401, we have an Exhibit D,
3401.
3401. And let me know. I'll wait for you to get there. And
I'm at 3401. Just Exhibit D.
this is Exhibit D, which will be a ways down because I think Exhibit B was the instructions we were working on with some comments, but Exhibit D is just one page. And it's, I think Mr. Altenburn had prepared an instruction that parts of we were okay with, but then his instruction, I think, referred to a California case and that the plaintiff or the deceased had to be suffering from a mental illness or something along those lines. We found 2 Florida cases that talk about, well, if there's a quote, when you get to 34OD, you'll see there are quotes from both cases. Excuse me, 3401 Exhibit D. There are quotes from both cases. There's a Florida First District case.
Just so I'm clear, is that the Nelson versus Seaboard?
Yes, Your Honor, it is.
On there.
That quote that the person being sued had to have driven the deceased beyond the point where she could rationally decide against killing herself, and then that case is then cited in a more recent federal case, and they agree with that, and then they say they refer to such severe stress and emotional upheaval that she killed herself in response to an uncontrollable impulse. So the Florida case law, our position is, does not require the person have a mental illness. You can have, and if one just sort of steps back, I think, and thinks about it from a common sense point of view, not everybody who commits suicide has a mental illness. I mean, some people do it, for other reasons that, they feel overwhelmed for whatever. It could be a variety of things. It could be financial. It could be emotional. It could be family. And in this case, it was family. And those people don't necessarily have a what is it, the DSM or whatever mental illness. And so we would argue, and there is, I think we agree, both sides agree there's no standard instruction on this, but that we think that when it comes down to describing this part of it, it should be the Florida law and not the California law.
Mr. Altenburn.
Your Honor, I filed a fairly extensive memo on this, and I apologize on my own version of this. I don't have the DIN number, but it was filed on September 6th of this month at 9:53 a.m. The request is...
That's 3346.
3346. And basically, Mr. Elliott is right that there isn't, not only is there no standard instruction on this, but to, I think, the best of all of our research, none of us have found a case that went to trial on this issue any place in the United States. And so the case law that he's relying upon, and the case law for that matter that I've given to the court from other states, is cases that are primarily discussing, well, did it pass a motion to dismiss, or did it pass a motion for summary judgment, or not? In many of the cases, it did not pass those things. And so this case law is, I think, helpful to the court, but the notion that anyone in the United States of America has something that they've settled on as the instruction to give to a jury in this case just isn't there. So this is probably the hardest and biggest legal issue for both sides of this case, and the most likely issue to be one that we would raise on appeal one way or the other.
And is your proposed instruction one that's at the bottom of page 2?
Bottom of page 2.
Of your memo?
No. Actually, the memo goes forward and gives you 3 instructions at the end, because I believe that the instruction should be limited. If I can kind of just go through this very quickly.
Yes, sir.
Everybody here and in all the other cases around the country agreed that there's something more you need to say to establish a claim for intentional infliction of emotional distress that results in suicide, because of the strong common law presumption that suicide is an intervening break in the chain of causation. Those cases clearly, as a result, are focused on the concept of foreseeability. Some of the case law is discussing it in the sense of, well, what's sort of the duty you owe to another person here that would be such that it would be foreseeable that suicide could occur. And some cases have focused on, well, does the conduct cause the suicide as a proximate cause concept, not of the damages, because once the person is dead, the wrongful death damages are a fairly easy proximate cause issue. So my position on this is, if you look at Tate, which is the case that they relied on from California, is one of the, if not the earliest case, one of the earliest cases from about 1960. The whole focus there is on this being a tort of intent, and that it has to be extreme conduct. And so my first preference is one that is, and I've argued this to you before in motion to dismiss, and you did not really accept this, so I'm not expecting that you're going to say, yes, I'm right. But because of the nature of this tort, and especially in this attenuated situation where the tort is somewhat difficult to explain in terms of outrage just as a basic tort, keeping in mind that we have no right to comparative negligence, we have no right to contribution from anyone else. This tort puts us, because it's an intentional tort, on for the ride for the whole 9 yards of damages, that the standard for this should be one that requires that the person committing the extreme and outrageous conduct must have actually intended to cause severe emotional injury to the plaintiff for the purpose of causing the plaintiff to commit suicide. The situation, and I've admitted this before, that if someone comes and says, you know, your only real solution here, sir, is the only option you've got left is suicide, and you know, here's a gun to do it with, or assist them, pushes them to get them very upset to have them commit suicide, I think that states a cause of action. Now, that factually is not what we have here, but if I'm arguing to a court that can set, you know, a binding rule for the state of Florida, I think in light of the strong standards in the case law we have on negligent infliction, that where we stand in the state right now is that it can't be reckless conduct that causes this. It has to be intentional. I intend to create an emotional distress in you, and it has to be stress that was done actually because my intent is to have you commit suicide. So that's the first instruction that I have requested here. If you want me to stop and we can go to the second one after that, that's fine.
Well, I will tell you, I'm not going to rule from the bench.
Yes.
But
okay.
Mr. Elliott, did you want to say anything there, or do you want Mr. Altenburn to keep going?
I think he can keep. I think I heard him say you didn't buy that the first time, so I'm not going to say anything to try to help him out. No offense.
The second part of this, and again, it's laid out rather carefully in the memorandum, is that if we get to the issue of recklessness, then recklessness is a standard that needs to be more specific in these. And because a lay sense of what is reckless and what the law has as the standard of reckless are really pretty different concepts at this point in time. And there is actually a standard on recklessness that exists in the restatement that has been cited in Florida. And in my memorandum, it's at the bottom of page 7. The problem with it is that even I, reading it with the text in front of me, can't understand it. It's very complicated. so I won't even try to read it, but what I have done is try to turn it into something closer to plain English. And that instruction is that in order for All Children's Hospital to have acted with reckless disregard of a high probability of causing severe emotional distress to Beata Kowalski, resulting in suicide, A, one or more of its employees must have intentionally performed acts or made statements that when that person knew or had reason to know of facts which would lead a reasonable person to realize that his or her act created an unreasonable risk of suicide by Beata Kowalski. B, the act or statement must be more than an act of negligence. It must create a substantially higher risk of suicide than the risk that would be created by a negligent person acting unreasonably. And so I have, if you decide that it can be either intentional or reckless, I'm asked for the instruction to incorporate that concept. And finally, really on either of these approaches, because I've done it in all of the instructions at the end. There's three that I'm proposing at the end. The Nelson case that they have relied upon, again, was not a jury instruction, and even more importantly, it was in the context of FELA, which has the federal standard for that, which is akin to workers' compensation, is more like the slightest negligence is all it takes to be liable under FELA. So the Nelson case is not a very strong foundation for us to try to jump from a workers' comp standard to something as high as the intentional infliction of emotional distress standard. But if we do that, I mean, what I've shown you in the memo is the concept of whether it's an irresistible or a uncontrollable impulse. That does show up around the country. And I think they prefer uncontrollable. I don't really think I care one way or the other whether it's irresistible or uncontrollable. But then the difficulty is, how do you explain what an uncontrollable impulse is? And the case law on that comes more from the state of Mississippi than from other places. And it tries to draw some fairly fine distinctions between mental conditions and mental illness. And that if it causes a mental illness rather than a mental condition, that may be enough. And they use that language to basically explain that it's an uncontrollable impulse. So in one of those cases, let's see if I can find the language here. The court actually goes to the testimony and says that the plaintiff's psychiatrist, Dr. Barnes, stated that if you asked Schomburger, the plaintiff, what he was going to do before he committed suicide, he would have said he was going to kill himself, and such acts were voluntary and with the knowledge of the consequences of his act. And as a result of that, they found that it did not pass a test where it would be sufficient to be a claim for intentional infliction. And the language that I have sorted through on this, that I think comes fairly close to the other cases that have this irresistible or uncontrollable impulse, would be that she did not have the ability to know what she was doing. And so the instruction that I have given at the end, let me read the language here, is that in order for All Children's Hospital to have acted with reckless disregard of a high probability of causing severe emotional distress to Beata Kowalski, resulting in suicide, excuse me, I'm reading the wrong one. For extreme and outrageous conduct to be a legal cause of suicide, the extreme conduct must have caused a mental illness that resulted in an uncontrollable impulse to commit suicide. The uncontrollable impulse must be sufficient that it can be said that the plaintiff did not have the ability to know what she was doing so that she could not stop herself from committing suicide. And I believe that that is better than the language that they have suggested, which is in a paragraph that actually begins in other words. It was just kind of a colloquial restatement of what Nelson was holding would be the cause of action in that. So those are the three positions that I'm taking on the jury instructions.
Mr. Elegant.
Yes, Chris, could you tell me what, I think you didn't have the docket and index number, but what date that was? I think I missed that.
It's 3346, DIN 3346.
Oh, okay, that's bad. Okay, let me write that down. 3346. Well, rather than get into the detail on it for the moment, here, sort of working backwards, but could not stop herself. The problem with that is, Your Honor, that we don't think that reflects all the circumstances, and particularly circumstances in this case. Here, and again, I admit to being the least knowledgeable of this, but my impression is that the plaintiff's position is going to be, she concluded this was the only way. This was the only way her daughter was going to get released from what she thought was an untenable situation. And that's, is that uncontrolled, is that couldn't stop herself? That may be, hey, look, I mean, it would be like a person that had extreme debts and he's worried about taking his family under. He says, but I've got $1 million worth of life insurance and the suicide exclusion is past that. I'm gonna make my family rich. I mean, that's not couldn't stop yourself. That's in a sense a logical, outcome. So that's a problem I have. Second, the Nelson case is a comp case, but it's then cited by the federal court, Middle District, in 2008 in a state of Duckett versus CNN. I think that court thought it had broader application. I think that if Your Honor could give us some guidance, and I understand not wanting to roll from the bench on this because I would agree it's an involved issue. I think if you could give us some guidance and say, and not necessarily at the moment, but say, look, I'm not going to require a finding of that she was mentally ill, or I am going to find it. I am going to require that. And again, our position is Florida law doesn't require it. But I think if you told us that, you could rule on that narrow point. I would be hopeful that Mr. Altmer and I could work out some language and at least give you an instruction that if it wasn't agreed to, it would have, okay, here's what we want, here's what they want. And then you could make those choices.
Let me ask you this, Mr. Elegant. So you're suggesting that the law should recognize or does recognize a person who rationally decides to end their own life as able to, or her estate to collect for a rational decision to die by suicide?
If to collect from someone that drove them to it, to make that to where they said, this is my only chance. Now, you and I might not say that's rational, but that person might have thought it was. In other words, the getting back to, and I guess one other point, I don't think, and I think this goes to your question, I don't think the defendant has to have intended that the person commit suicide. I think I heard that as one of the arguments, and that may be the one that you didn't agree with, but anyway, because you could do something that's and the idea that the person may commit suicide never enters your mind, never enters the defendant's mind, but they still do these things, and that's a foreseeable outcome. So, I mean, I don't think I think we would all, I hope we would all agree that there are better alternatives to suicide, and people ought not to do it, and that, but I don't think and again, it says had driven the deceased beyond the point where she could rationally decide against killing herself. So I'm not saying it has to be a rational decision. I'm saying I see people could get there without being mentally ill. Okay. In the Florida one does not say, I don't mean to say that says it's a rational decision. I was giving an example where I think you could say some people could get to that conclusion. Now if it's somebody that's, somebody that's been, to use my earlier example, driven up their own debts, and they're, and now they feel at their wits' end. They've done it to themselves. But, if they were being hounded by somebody, saying you got to make this right, I'm going to put you in jail. I'm coming after your family if you don't do this. Then, have they been pushed to it? Is it still a rational decision? Maybe not. But
let me ask you this, Mr. Elegant, and
yeah.
and I don't know the answer to this, and I have seen press reports about cases involving cyberbullying and a person taking their life. I seem to think that those were in criminal context, maybe not in the civil context. But isn't that really what you're kind of talking about, that a person gets hounded so much in a la the cyberbullying that causes a person to take their life? And then I don't recall in those press reports any sort of necessary finding of the decedent having a mental illness.
Exactly. And yes, I think, Your Honor, that's one of the places we look for research on this, and I don't think we found a civil one either. I think there is a statute that addresses cyberbullying, so that's a little different. So I didn't think we would really analogize to that because we don't have a statute here. But yes, I think that is comparable. And if and again, did the bully intend a suicide? Probably not. They probably thought they were having fun, and they were, picking on this poor person. But, so I think that's all in the same genre, Your Honor. And I just don't think I don't think we have to have a mental illness is our point. And I think if we have a ruling on that, I think if we couldn't work out all the language, I think we could give you an instruction like we did a little bit earlier on the pre-opening ones that said, well, plaintiff wants this, defense wants this.
Mr. Altman, any further comments?
Yeah, two or three things. First, very quickly, the federal case he cited that followed Nelson took me a while to find it. It's not actually in Westlaw, but it was an order entered by Judge Terrell Hodges on a 12B6 motion to dismiss, emphasizing, by the way, that he was on a motion to dismiss and not a motion for summary judgment.
So that one is not indexed in Westlaw at all?
It's in Lexis if you have access to it, but I didn't have access to Lexis.
I don't think I have Lexis.
I could look it up on Google, and I did find it. But
I'm sorry. I'll be glad to send it around. Sorry.
Yeah, could you send it to my judicial assistant? But there's enough Judge Hodges clerks running around that I'm sure we could.
It is on the internet because I did find it. What I can tell you about it is it's a case where a woman whose 2-year-old child was missing got talked into giving an interview to someone named Nancy Grace, who apparently was one of the people that puts things exciting on CNN News. And the allegations were that she ambushed her in the interview with false statements while she has a child that she's trying to find at that moment in time. And CNN announced to her they were going to broadcast it the next day. And so hours before that broadcast, she committed suicide. And Judge Hodges let that stand on a motion to dismiss. Well, that's very much one-on-one bullying with a person that you're seeing or hearing it. I think it was a telephone.
So Judge Hodges allowed that case to proceed?
To proceed on a motion to dismiss. And again, emphasizing he wasn't ruling on a summary judgment in the order I read. And I can tell you from a bullying standpoint, and I have cited the case, there is a case from Illinois, Hankins versus Alpha Kappa, which is at 447 Fed Sup 3rd 672, Northern District of Illinois, 2020, where another case survived a motion to dismiss, but that was a girl actually living in a sorority house, and the sorority sisters were hazing her in a very extreme fashion, and they knew and could see that she was emotionally upset, and she committed suicide. My point, and by the way, I don't know that it ever gets prosecuted actually, but assisting suicide is a form of culpable negligent manslaughter in the state of Florida. I'm on that committee. We've never done a jury instruction on assisting suicide culpable negligence. The instruction just says, if you need one, you're going to have to write it yourself. So I don't know how we jump exactly from the criminal law to this, but I understand there's a bit of a parallel. But all of those things have been where there was a mens rea, where people were intending to do something, or at least it arose to the extreme level of culpable negligence for purposes of manslaughter. And that's really not what we have here. So I don't know that we can use that standard. And so, as Mr. Ellicott has explained, this woman decided to commit suicide as the only way to get her child released. She was in a situation where the trial judge wanted to have the dependency hearing a month later, and she didn't want to wait to win a dependency hearing, which they claimed she could have won if it had taken place. It never took place. But, you know, the decision she made was actually, I guess, effective, because the child was released by the court almost as soon as she committed suicide. It is, in my mind, an irrational decision, but it was something that she thought through in some level. And so I'm just saying that equating this to bullying, there's got to be some language that is more refined than that. And I think that if you reject my first instruction, that one of the second or the third come very close to the mark.
What I will promise is I will try to have some sort of thoughts to you by Monday as to where I am with this. I don't know how fleshed out an instruction will be, but at least I'll try to narrow the playing field such that we can proceed further.
Because and that would be very helpful, because that way we know what is relevant and irrelevant to some degree going down the road.
Well, I appreciate this conversation, because this has also been helpful for me to help frame where and how I'm going to be looking at this.
Your Honor, it's about almost 11:30, and you had indicated that you didn't mind if we ended early. So although there's other things we could go on to, it may be a good time to stop this. I do know we had at least one or two trial concerns that we wanted to bring up, but I guess Greg's not here.
Without Mr. Anderson being here.
Mr. Anderson's not here, we shouldn't do that.
Yeah, that was my thought.
Well, is it something that you can at least let Mr. Ellicott know that they can relay?
Sure.
So that you can at least be thinking about it?
Yeah, sure, Your Honor. There's it's back to a skilled witness issue. Dr. Napolitano, for example, he was here as a corporate representative. He gave a deposition, and he was a member of the Risk Management Committee. His deposition was narrowly tailored and ordered by this court only to address Risk Management Committee issues. Plaintiffs want to play his deposition. We believe he's not a skilled witness. He may be an MD, but he didn't have any clinical involvement with Maya Kowalski. He's actually a neonatologist. His role and function was simply to talk about Risk Management Committee issues, and for that reason, we believe that he's not a skilled witness. He should come live, and I would point, Your Honor, to Your Honor's previous order at DIN 3361, where we addressed a similar issue, where we had a licensed mental health counselor and an RN, but both of those weren't functioning as RNs, or they weren't functioning as a licensed mental health counselor. We believe Dr. Napolitano fits within that. He's ready, willing, and able to come testify, and this court's also indicated that we didn't want this trial to be hitting play and playing depositions a lot, so we think that Dr. Napolitano, whenever they decide to call him, should be here live and not played for the same reasons and logic set forth in DIN 3361.
So Mr. Ellicott can relay that concern, and we can, if y'all can't work it out amongst yourselves, then I'm sure in the near future we can make a ruling on that.
Yeah, and there's also an attorney, Jackie Crane, that falls into that role, but we can discuss those issues later.
Anything else that you all want and or need from me at this time?
Mr. Ellicott's on Zoom in front of me right now. Can I ask him whether there's a good time I can set a Zoom for this afternoon for us to meet?
Yes, I have something at 1, but I'm sure, let's put it away. If it's not done by 2, I'm going to leave anyways.
All right.
Judge, and Chris, one one thing, just sort of an observation I would make on the intentional infliction of suicide is that, and I agree this is a complicated issue or challenging issue, whatever. I think one thing we can all keep in mind maybe as we head toward the end of the trial is there may be a way to deal with some of these things with a special verdict form. And not necessarily just that instruction, but some of the other stuff. I mean, I appreciate the verdict form is probably going to be a significant anyway, but.
Well, let me reiterate my comment. I don't even remember when I made it, but to the extent I can have interrogatories that will prevent us from having to try an issue again, even if, we might not agree that something needs to be found, getting the interrogatory response is going to be helpful. So to the extent we can logically make that happen, I probably want to craft them to allow that to happen.
You did make that comment last week, and hopefully Mr. Elegant and I, who worked with or against one another for a long, long time, can help you with that.
And I appreciate both of you. I know it's not easy in this case, and I appreciate your efforts.
Thank you, Your Honor.
Anything else?
No, Your Honor.
That's good.
We'll be in recess. Have a good afternoon.
Thank you.